Who is for respondent number 13? Number 13. Respondent number 13. I'm for respondent number 13. Who is for respondent number 10?
I'm appealing for respondent number 10, my lord. My lord, I filed my affidavit, my lord.
That we have seen. What is the status of the inquiry? Status of the inquiry.
I have not filed it, my lord, but then I was supposed to file my affidavit, my lord. In fact, my lord, the allegation that has been alleged, my lord, we have taken steps, my lord. In fact, we have.
What is the status of that inquiry?
Status, my lord. Then I have to take instructions on that, my lord.
You give it to us in a seal cover.
My lord.
Friday.
Friday.
Give it to us in a seal cover. What is the status?
Status report, my lord. Oblige, my lord.
List on Friday. First.
My lord, I appear for the petitioner.
Yes, have you received the affidavit of the respondent number 10?
Not yet. The affidavit has been served upon my client, my lord. I'll receive it since I could not go to Itanagar. I'll get it in Guwahati within 2 days, my lord.
There is a discrete inquiry going on. Sorry,
Yes,
my
my
voice
lord.
is bad. Discrete inquiry is going on, so we wanted for the report status. We are fixing
Yes,
it
my
on
lord.
Friday. We are fixing it on Friday to see the
Friday,
status
my
of that inquiry. This Friday.
My lord, I will have to appear by VC, my lord, on Friday.
It's okay, doesn't matter. We approach the registry, it can be arranged.
Yes, sir.
List on 21st. enabling the respondent number 10. To place the up-to-date status of the investigation. To the status of the two investigations, which shall be placed in a silco.
Much obliged.
Item number 4. It was 3 first. Three we have I think number 3 we have not absorbed. It was 3.
Roman Council. I think 4.
I think number 3.
Oh, 3. Okay.
Yes, you are appearing for the state.
Lordship. I haven't gone through also, Lordship. Can this matter be taken up tomorrow? Lordship.
See, do you have the copy of the order of the school first at the admission stage? Order of 29th of November 2011, 2021. Do you have a copy of
Yes.
the order?
Yes.
You have a copy of the order.
That is our order itself, Lordship, government's order.
That's what we want to know. If you do not.
He
have
was the
the-
respondent in the writ petition.
That's
The
right.
appellant was.
Go through this paragraph and tell us tomorrow or day after whenever. Go through para 10 and tell us.
Paratin. Paratin of the order.
Para 10, the order dated 29th of November, first order.
Order 29/11/2021 order का paragraph 3 को बोल रहा. No, in the order, see in the order.
Order sheet, these are go to order sheet.
First. इससे आगे में. ये.
That's the order. Para 10.
Lordship.
Have you taken any steps thereafter?
No.
So this is a conditional stay. Because if somebody's seniority,
Yes.
there's a difference between direct recruitment and de-promoting. So that is why the coordinate bench observed at para 10. So after this, have you followed any rules regarding the promotion of the respondents in the direct recruiters hearing? Because this is the guideline already given to you. This is a conditional stay.
Yes.
So whether the department has taken any steps after this.
No.
Let us.
It's in authorities' mind, there's a stay there, stays there, they haven't
No, this is
gone
the-
through the condition also, Lord, so this, they
Wait.
might not have gone through the condition also. We have also filed our affidavit here in this additional affidavit.
Yes, ma'am, when do you want?
Not so far.
He wants after vacation because stay order is in his favor. What the department wants, that is more important.
If they are ready, Lordship, I am ready day after tomorrow also,
Tuesday next,
next Tuesday, Lordship.
on the prayer of the council for
Much
the
okay.
petition. Before that, you write, in this appeal, the stay order is in force since 29/11/2021. On the prayer of the council for the appellant list on 28, not 28, 25th. Hearing.
Well, this is appeal against the acquittal against the impugned order dated 9/9/2022 passed by 11th Session Judge, West Cumming District, in session case number 9/2021.
What is the illegality done?
Well, there are two illegalities. My limb of arguments would be on twofold. My lord. The first, Arms Act was invoked, and at the time of taking cognizance under 209 of the CRPC, by the learned Chief Judicial Magistrate has committed a patent error, because Section 39 of the Arms Act says it is a requirement under law that previous sanction from DEM is a must to institute the criminal proceedings under the Arms Act. Now, the IO of the case, while filing the charge sheet, has not complied with it. Second aspect, my lord, even both ocular and the direct evidence are in my favor, for the reasons that both of them went to jungle for a hunting, my lord. By a mistaken identity, he was shot. And after killing him on the spot, the accused came to the police station, reported, my lord, to the police station that he has killed this person in this manner. But, my lord, that was reduced into writing by the IO of the case. So therefore, the first part under Section 25 of the Evidence Act will not come, because that is not a substantive piece of evidence. But when he comes and confessed, and the weapon, that is gun, which was recovered on his identifications and the place of occurrence from where the gun was recovered, then what happens, my lord? Section 27 will come into play. And that is exactly, my lord, what will be read with the Section 8 of the Evidence Act, because that is admissible. That is amounting to a confession, my lord.
Was there any corroboration?
Yes. The arms was recovered and it was sent to the FSL.
Arms was recovered at the instance of the
Accused.
whether it was a confession before this police station or outside.
Yes. Full.
Was it recorded in the case diary?
Recorded in the case diary. Now, my lord, the technical part. It is recorded in the case diary, prima facie discloses. And then, my lord, the learned court below, in the absence of prosecution sanction from the district magistrate under Section 39 of the Arms Act, frame 1 head charge. Arms Act was dropped. And the trial was conducted under Section 302 of the Indian Penal Code.
What is the forensic report?
Forensic process, yes. The live
The bullet injury,
correct, everything. This closes, my lord.
the bullet injury that the victim sustained
Correct.
was from this particular
Yes, yes,
gun.
yes.
Same gun.
The same gun. So, therefore, my lord, acquittal by the learned court below, prima facie on a patent procedural error. My lord. Now, for example, my lord will appreciate Section 209 of the CRPC. Now, that is, learned Chief Judicial Magistrate doesn't have the power, because the section invoked was 302 of the Indian Penal Code, which is exclusively triable by the Court of Session. So therefore, before making the committal, the learned court below, especially the Chief Judicial Magistrate, ought to have appreciate the objective of Section 207 of the CRPC. Then, at the first place, in the absence of the prosecution sanctions, he ought to have directed the IO of the case, the prosecution, to obtain the prosecution sanction, my lord. So this aspect was not done, my lord. Therefore, my lord, this is very serious illegality, my lord. You are there in this case.
For the respondent, amicus.
Yes.
Am I not, before my learned friend proceeds any further, it seems the PP is not here, the main party. PP is not present today, it seems. Can it be taken up tomorrow, Lordship?
There is only one PP.
Yes, Lordship, because the main party is not here. Tomorrow, Lordship.
Professor, my lord, I demonstrated my case.
I deeply apologize, Your Lordship. Your Lordship, the file has been misplaced, Your Lordship. If Your Lordship take up this matter tomorrow,
No issue. You have this paper.
yes, we have received the paperwork.
Case was registered even under Arms Act also, but it
Yes,
was
my lord.
dropped at the time of
Drop.
framing of charge.
Framing of the charge. He could not proceed because there was no previous sanction from the magistrate, which is condition precedent for institutions of a criminal case under Arms Act. My lord. Right from my lord, taking cognizance, framing of the charge, patent illegalities were committed by the learned court below.
We'll have it day after tomorrow.
My
Thursday.
lord. Thursday.
Thursday.
Okay. No issue.
Deeply.
As the public prosecutor. The state is not available today.
Oh, 20, my lord, 20, I have some difficulty. 20. Where is this? 20 color, no? Tomorrow is 19. My lord, आज 18. My lord, kindly accommodate me tomorrow. 20, I have personal difficulties.
21st,
21st, then fine.
okay, we'll have it on 21st. List on 21st.
Item number 1. Item 1. Darshan Singh. Darshan Singh. 1.
There will be some mention. Please, let the matter be called. Let the matter be called.
Yeah, Lordship. I'd like to mention item number, Lordship, 17, 18, Lordship. Lordship, this matter may be list after, Lordship, 2 week, Lordship. Lordship, here, Lordship, item number 17, Lordship, B. Picha, Lordships, have some personal difficulties, Lordship. Just inform, Lordship. Just inform me, Lordship. But Lordship, I am the
This is
petitioner.
a serious matter.
Yes, Lordship.
If we have to adjourn 17, 18, it will go from 13. Wait for your turn.
17, 18, Lordship.
1718. Right?
Yes, yes, Lordship.
Is not it a serious matter? What is that? I think it's 17. Nine. Today's list is not for me. Please take your seat. Let me see the list. Get an extra list. Get an extra list. Extra help. Yes. Copper cell. Yes. Okay, we can do it. Done. Why it has come for order today? Any idea?
This is today come for lordship for IA lordship for vacations of the interim order lordship. Lordship, here I am the petitioner, but lordship, here lordship, the petitioner for IA lordship has some personal difficulties lordship. Just he informed lordship, he has some personal difficulties lordship. B pitcher lordship, IA petitioner lordship.
When the IA was filed,
For vacations of the interim order lordship.
when it was filed,
Lordship,
when it was filed,
lordship, check the file. Lordship, this is file. Uh, in February lordship, month of February lordship. I is file.
why 226 will not be applicable?
Lordship, not in IA lordship, we did not file lordship.
That is the reason.
Yes, lordship, not file lordship, not required lordship. In affidavit in reply is filed by the state respondent lordship. So
226(3). Are we aware of the provisions of Article 226(3)?
lordship, here lordship, IA petitioner lordship, B Pichai is out of station lordship. This is the problem lordship.
Read 226(3).
Lordship.
The submitted. That counsel for the applicant. B Picha is presently out of station. It will be able list on Monday next week. Date to provide.
Lordship, item number 18, interim may be continued, Lordship, still.
We are not going to extend the interim order. The reasons are known.
Lordship, then Lordship, matter may be taken up, Lordship, today itself, Lordship, otherwise. Otherwise, Lordship, may please to taken up the matter, Lordship, today itself, Lordship.
Doesn't matter.
Okay, Lordship. Much obliged.
May I proceed? Lordship, I beg to mention item number 7 on behalf of Uttam Dekha.
Why? What is the reason for mentioning?
My lord, my senior counsel is not there, so
So
cannot
take
take up
the
the case.
advantage. Take the advantage. If we have to dismiss it, we will dismiss it in presence of your senior counsel. If you have to allow it, we will allow it in your presence. Choice is yours. Quickly. Okay. Yes. So answering some vacation go to the tonight. Yes. What is the prayer?
Your beg to mention item number 23,
Hmm.
since leading counsel is out of station, so this matter may be adjourned to 2 weeks.
His name is not there in the list of advocates' absence. There is no procedure here. Okay, let the matter reach, we'll see. Not at this stage. Let the matter reach.
My lord, I beg to mention item number 16, my lord. But in this contempt, my lord, an affidavit in opposition has been filed. We want to file a reply. The reply is almost ready, my lord. By this week, we can file it, my lord, because certain things we want to bring it on record, my lord, regarding the investigations that they have done.
Mr. Katanier, contempt is between the contender and the court. What reply
Yes,
you
right.
need to file? What
Yes, my
reply you
lord.
need to file?
My lord, there are some aspects, my lord, which needs to be divulged before this court, because court has to lift the veil and see, my lord, what is the mischief that is going on behind these investigations. Because the order of the writ petition was passed on 12th of July, my lord, 23, and on that date only they had given sanction for prosecution, my lord, and they were waiting, and actual culprit has not been investigated upon. That is evident from the statements they have taken from us, my lord. So we want to bring it on record, my lord.
But whether a read court can look into that aspect.
My lord, just to bring it on record, my lord, because otherwise taking a handle from this court, if this contempt is disposed of, again the investigation will die down in its natural death, because similar cases were registered much after the case that was filed by the complainant, and in those cases action has been done. Only in my case action has not been done because of some vested interest, my lord. So in that regard, we need to file a reply. At least it will be open before the court to take the requisite decisions then.
Mr. Katanier, that is why you are saying this is a contempt. It is only between the court and the contender.
Yes, my lord.
Your affidavit, how it will help the
My lord,
adjudication of this matter.
it will help, because I want to show the manner in which they are proceeding, my lord.
Is that amount of non-compliance?
But it implies, my lord, that there is a slip-study investigation that has been initiated only after filing of this writ petition, my lord. So my client cannot go on coming to the court year after year for the same thing, my lord. So it can be
When are you
divulged
filing?
before the court.
When are you filing?
My lord, here I am appealing for the contempt, my lord.
When are you
By
filing?
this week, my lord, it's ready, my lord. We'll just file it. May be fixed after the vacation. We'll do the hearing, my lord.
Give us a date. When are you filing?
My lord, by this week, end of this week, by Friday, my lord.
Are you
because
sure?
it is ready.
Okay. Mr. M. Khatani, counsel appearing to online, learned counsel appearing to online. On behalf of the petitioner submitted that the petitioner shall submit an affidavit in the matter by the end of this week. Which is essential to establish the case that the respondents have not yet complied with the order of the court. Considering the same, the petitioner is allowed to file such affidavit on or before 24/06/2024. List on 16th July.
My lord, 16 will be difficult, my lord, at least on 22nd, my lord, or 24th.
22nd July.
Oblige, my lord.
In the meanwhile, the respondent contempts may file their reply, if any, to such affidavit of the petition. Okay.
Much obliged.
Obliged.
All right, I beg to mention item number 10 and 13, my lord, on behalf of Charpok Modi, counsel for the petitioners, my lord.
The counsel for the petition, Mr. C. Modi, list after answering summer vacation on the date to be fixed by the registry. Okay.
All right.
Yes, brother.
Yeah, my lord, that item number 19 for the, my lord, give a 1 week time for the filing of that implicate to the vigilance commissioners as per the this direction of the Honorable Court. Order dated the 10/23/2024. This Honorable Court is directed to the petitioner for the implicate to the Vigilance Commission upon the questions. So, my lord, I ready to filing that.
When are you going to file?
1 week, my lord. 1 week I will file it.
When do you want? When do you want?
1 week today is, my lord, next week, just give 1 week, next week, my lord.
And the period. Mr. P. Bui, Metabia Jones for a week. Okay.
I will assume.
Mr. Navam,
My lord, I am 1 to 4, my lord. Respondent number 1 to 4, my lord.
Mr. Ranu, not additional advocate general. For the respondent numbers 1 to 4. Okay.
Lordship, I beg to mention item number 5 on behalf of L. Lombe.
Wait, yes.
My lord, I beg to mention item number 3. My lord, this matter may kindly listed after 3 weeks. I have taken consent from the petitioner.
The stay order is in force.
Yes, yes.
So
My lord, in that case, interim may be continued, my lord.
I am for the, my lord, respondent number 4.
I am for the petitioner.
what is? Okay. Then she'll quickly. Let's see some of it. Yes.
Much obliged.
May I please, my lord? My lord, this is similar matter, my lord. Yesterday, my elder colleague, Tara has my one matter, my lord. This is regarding allocation of this retail outlet.
State your facts.
My lord, Bharat Petroleum Corporation Limited, my lord. They have issued advertisement for appointment of regular rural retail outlet, my lord, on 28/6/2023. Responding to that advertisement, my lord, the petitioner, he has submitted online application on 16/10/2023.
Yes.
Thereafter, my lord, on receipt of my application, the B Bharat Petroleum Corporation Limited, by email, my lord, have invited the petitioner for the draw of lottery, my lord, lots. That was to be held on 28/12/2023. Then accordingly, my lord, the petitioner has participated in the lots draw, my lord. And he was provisionally selected, and that was intimated to the petitioner on 28/12/2023, my lord. Thereafter, my lord, there were certain formalities to be performed by the petitioner, my lord. As advised by the, my lord, this corporation, my lord, the petitioner has deposited the initial security deposit and uploaded the same document, my lord, on the portal of the BPCL, my lord, on 21/1/2024. Again, my lord, by the email, my lord, petitioner was again advised to upload rectified or corrected document, my lord. And petitioner responded to that advice, my lord. He has uploaded the corrected document, my lord. Now, my lord, after the submission of all the documents, my lord, by email letter, my lord, of 8/6/2024, my lord, the petitioner was informed that he has been found to be ineligible, my lord. My lord, may kindly come to this impugned order, my lord, which I have challenged, my lord. That is, my lord. My lord, at page number 52, my lord, in lecture 7.
Yes.
My lord, this is subject application for award of RO dealership at on NH13 within so from IOC ROMS Kengam filling station towards Mangin district of Shah, State Arunachal Pradesh, and ST category advertising on 28 June 2023. Now, my lord, kindly come to the ground for rejection of my candidature, my lord. Number 3, my lord. Serial number 3. At the same page, my lord. However, we have not received the required document from you within the stipulated time as detailed below. Correct name of oil company not mentioned in submitted land document. Now, my lord, may kindly turn to page number 53 again. Letter from competent authorities certifying that lease deed is executed as per Stamp Act not submitted. Serial number 5, my lord. Since it was rejected on these two grounds, my lord, by clarifying all the doubt, my lord, I have submitted representation, my lord. As for the as they have provided in serial number 5, my lord. In case you have any grievances against the rejection of your candidature as mentioned above, you may make your representation by 18 June 2024. So, my lord, accordingly, my lord, since my candidature was rejected on the two grounds, my lord, by explaining everything, my lord, I have submitted representation on 15/6/2024. Although, my lord, the date is written as 14, my lord, it was emailed in the evening of 15, my lord, in the portal of the corporation. Now, after submission of my this representation, my lord, as they have given me the privilege to submit representation, my lord, if I have any grievances. on the rejection of my application, my lord. I have submitted this representation, my lord. Now, my lord, without attending to my representation, my lord, the corporation, they have given the date of this lot draw on 19, my lord, at 11:55 a.m., my lord. That is tomorrow, my lord, it will be drawn, my lord.
Under which category?
My lord.
Under which category?
Under category 1, my lord. I have applied for category 1, my lord.
Now you have offered category 3.
Yes, my lord.
The lot is now a category 3 or category 2. This tomorrow that is going to happen. For which category?
For category 1, my lord, the draw will be, my lord.
Where is it?
My lord.
Which page?
My lord, page number 18, my lord. NHR 2, my lord. My lord, on the right hand side, my lord, in the middle, my lord, where the column has been prepared, my lord. Page number 18.
Where is the brochure?
My lord.
Brochure.
Page number 18, my lord, 18. NHR 2. At my lord, right hand side, between two lines, my lord, there is two lines drawn, my lord. At the right hand side, my lord, time and date is given, my lord. Draw lot on 19 June 2024 at 11:55 a.m. My lord, got it, my lord.
Any such selection? Retail outlet dealership. Pertaining to his number may not mark going to assess blue market. In terms of the advertisement. Notice. This is by the BPCL. The newspaper of 2806 published in the newspapers in the state of Arunachal Pradesh of 2806/2023 shall be subject to the outcome of this petition.
Obliged, my lord.
Yes, I think.
Yeah, please, Your Lordship. Here the impugn order passed by the Learned Deputy Commissioner is under challenge, Your Lordship. Whereby the Learned Deputy Commissioner has exceeded his jurisdiction. And the same order was passed in contravention with the Arbitration and Conciliation Act. When there is a contract agreement between the two parties. Now the Deputy Commissioner, on the basis of a complaint filed by the here respondent, passed the impugn order, directed the petitioner in the last paragraph, that is page number 199, Your Lordship, is the impugn order. to resolve the issue regarding payment works between the MS Kamakya Infracom Private Limited and Virtual Parang Hydropower Project Limited. A meeting is hereby fixed on 20 June 2024 at so and so hours at DC's Conference Hall, DC Office, UPI. The following stakeholders are directed to attend the meeting positively. Lordship got it at page 199.
That's right.
And then last paragraph is that further the Virtual Parang Hydro Private Limited Camp Parang is directed to stop all the construction activity till the matter is resolved. The order is passed beyond the jurisdiction, Your Lordship. As there is a contract agreement, which I have annexed, Your Lordship.
Which
Page 55, Annexure D. And relevant portion is at page 62. Page 62, Lordship, there is an arbitration clause. Section 14, Lordship, disputes. 14.1 says, if any dispute arises between the employer and the contractor in connection with or the arising out of the contractor or the execution of the works, whether during the execution of the works or their completion, and whether before or after the repudiation or after termination of contract, including any disagreement by either party or with any action, inaction, opinion, instruction, determination, certificate or valuation of the engineer in charge, an attempt shall be made to resolve the matter in dispute amicably. Now, next, Your Lordship, 14.2 says, no dispute or difference arising between the contractor and the employer under or relating to or in connection with the contract shall be referred to arbitration unless an attempt has been first been made to settle the same amicably in accordance with subsection clause 14.1 above. Now 14.3 says any dispute or differences in respect of which the employer and the contractor have failed to reach at an amicable settlement pursuant to subclause 14.2 within 60 days of the first instance of referral of a dispute by a party to the other in writing shall be finally settled by the reference to the arbitration in accordance with the provisions of the rules of arbitration of the Indian Councilation of Arbitration, New Delhi, India. The provisions of the rules governing the proceeding of arbitration shall be strictly conforming to the Indian Arbitration and Conciliation Act 1996. An award made in pursuance thereof shall be final and binding on the parties. The seat and venue of the arbitration proceedings shall be New Delhi, so and so, so and so. This is the clause, Your Lordship. And section 8 of Arbitration and Conciliation Act also says, Your Lordship.
yes,
Power to refer parties to arbitration where there is an arbitration agreement. Judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the subsistence of the dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds that prima facie no valid agreement exists. As section 5 also says, Your Lordship, extent of judicial intervention, notwithstanding anything contained in any other law for the time being in force in matters governed by this part,
yes, Mr.
no judicial authority shall intervene except where so provided this part.
Your Lordship has seen, my Lord, this agreement contract, my Lord, that 14.2 then 14.1. My Lord, perhaps the DC issued, my Lord, considering the administrative agency, my lord, in view of this section 14(2) and 14(3), first chance was given for the amicable situation, my lord, for the amicable settlement. So day after tomorrow, that has been fixed, my lord. Why so rush to this court, my lord? He can attend and have an amicable solution, my lord. So that will end the entire matter, my lord. If there is no amicable solution, then in that case, my lord, the matter can be referred to arbitration, my lord, as per the agreement clause. So first chance was given to them, my lord, as per the DC orders, my lord. If your lordship see, my lord, agreement, this clause 14.1.
Petitioner is agreed only because there is a direction given, which according to the petitioner exceeded, the deputy commissioner has exceeded. Because
My humble submission, my lord, the DC has issued, my lord, in consonance with my lord 14.2 and 14.3. First chance for amicable settlement, my lord. That's why my lord, meeting has been convened, my lord, after tomorrow, my lord. That is the 20, my lord.
Lordship, I am sorry to say.
So he can have a, my lord, amicable settlement, so everything will be over, my lord.
Lordship, when there is a contract agreement, there is a dispute between the two parties. Here in the present case, Deputy Commissioner has no role at all, your lordship.
see, without any authority, he may not have interfered. There has to be something.
Lordship, the order was passed in the capacity of judicial officer, memo number PP/JUD, your lordship.
Obviously,
It's a
when
judicial
there is a complaint, my lord, he being a district administration, my lord, considering every, my lord, all the nook and corner, my lord, if there is supposed law and problem arises, my lord, because of the dispute, my lord. Then, my lord, in that what circumstance, my lord, the deputy commissioner will react, my lord. So considering all this, my lord, agreement clause, my lord, he has given the first chance. So that they can go for amicable settlement. If they don't have an amicable settlement, they can go for arbitration, my lord. I don't think so, my lord. The DC order is, my lord, indispensable, my lord. They can have a solution on 20, my lord. The order will become infractious, my lord. Because order has been passed conditional, my lord.
Saying we have it on Monday or Tuesday.
Yes, my lord.
Coming Monday.
Today is, my lord, 18. After tomorrow, my
We
lord.
have it on Monday.
Monday, my lord, yeah.
Lordship,
At this stage, we'll consider your prayer on Monday. That will be better. Take part in the meeting. Even this order continues, then we'll do the meeting.
Yes.
Lordship, Deputy Commissioner has completely no role here.
We know that. We know that. But
Judicial intervention cannot be warranted. your
an
lordship.
administrative head of the district, because 14.2 and 14.3 also matters to the amicable settlement. If matter goes in your favor, fine. Doesn't go in your favor, its petition is pending. We can consider on Monday.
As per your lordship, I have recently, we have also the matter
Now,
was
just
fixed
tell
on,
us, Mr. Singh, tell us,
the matter was,
leaving aside the arbitrator,
Hmm.
arbitrator never tries for any amicable settlement. Right? The amicable settlement has to be by somebody authority whom both of.
there was
parties
a
are-
minutes of meeting also was between the petitioner and the respondent.
Deputy motion.
Yes.
So wait till Monday. Let the motion come on Monday.
And the said meeting, lordship, which was fixed on 20th June,
Huh.
has already been postponed to 17 June.
Preponed,
Yesterday, after filing the case, we have received.
preponed or postponed.
Preponed.
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 17 June.
17 June, then it should be preponed, my lord. Because that is
Sorry,
20, my lord.
25th, 6, 25, 6. 25, 6.
We'll have
25.
it. We'll have it on 27, Thursday.
Lordship,
We'll have it on Thursday. Next Thursday.
My lord.
because thereafter there will be a vacation. The entire work is stalled, your lordship.
No, within 3-4
This is
days,
the
my lord, nothing
development
happened
work.
to solve, my lord.
Kindly
3-4 days,
see,
my lord.
The
17-6.
is directed to stop all construction activities till the matter is amicably solved.
See, when the matter is in dispute,
25th.
even if it is goes to the arbitrator,
In that case, Lordship, then observation will be made, Your Lordship. We will appear. Observation will be made. Otherwise, the order itself is illegal. Your Lordship.
Mr. A.K. Singh, the petitioner, and Mr. R.H. Nabam, London Edison Applicant General, Arunachal Pradesh. Mr. Nabam for 1 and 2.
My lord, I am for response number 2, my lord.
2.
2.
Is
One
there,
is, yes, that is Deputy Commissioner.
is there anyone for,
So for response number 1, my brother is appearing, my lord, Power Department.
you for 1? Please. 1 and R.H. Nabam.
And then I'll get instruction.
Regarding payment of payment for the works. There is a dispute pending before the petitioner and between the petition and the respondent number 3. The said dispute, said issue, to resolve the said issue, the Deputy Commissioner, Papumpare District, directed both the petitioner and the respondent number 3 to appear for a joint meeting on 20/06/2024 by circular dated 07/06/2024, which has now been rescheduled and fixed on which date?
25th, my lord.
25th.
25th, 6, 2.
25th, 6.
In the said circular dated 07/06/2024, the Learned Deputy Commissioner intimated the petitioner that till the matter is amicably resolved, it shall stop all the construction activities.
My lord, sorry to point it out, my lord. Now, my lord, as per the latest circular, that condition will be withdrawn, my lord. There is no more condition, my lord.
Okay, give me a call.
No condition.
Let application on 07/06. It is contended by the petitioner that the Deputy Commissioner Papumpare District exceeded his jurisdiction, directing it to stop all construction activities as the agreement between contains the agreement between the petitioner. Contract agreement and the government of Arunachal Pradesh and the Hyderabad Development Department. Contains arbitration clause regarding settlement of dispute. In that regard, Mr. Singh placed the provisions of clause 14.1, 14.2, and 14.3, as well as 14.4 for resolving the disputes. On the other hand, Mr. November Additional Advocate General, appearing for the Deputy Commissioner, Pabupara District, placed before the court the refreshed circular, the number pp.jud-0957/2024, dated 17/06/2024. While fixing the date of the meeting on 25/06/24 at 10 hours in its conference of doesn't contain any such clause directing the petitioner to stop all the construction activities till the matters amicably resolved that was available in his earlier circular dated 07/06/2024. What we could see from the circular, improved circular dated 07/06/2024, as well as the new circular dated 17/06/2024, placed before the court by Mr. Singh, counsel for the petitioner, is that the Deputy Commissioner, being the administrative head of the district, is trying to amicably resolve the dispute between the petitioner and the respondent number 3. Considering the provisions of clause 14.1, 14.2, 14.3 of the agreement between the petitioner and the respondent number 3. Improved circular dated August 2021 of the Deputy Commissioner 7/6/2024, as well as new circular dated 17/06/2024. The petitioner may participate in the said meeting fixed on 25/06/2024. It is up to the petitioner to appear before such and such. List of 27.
Let the material on 26, Your Lord. We will produce the 26. And in subsequent, this circular, so far as the earlier order is concerned, whereby it was directed to stop all the construction activities till the matter is amicably solved. In this circular, it has not been mentioned.
So that's but in that case, he can withdraw the said petition, being in fluxus. You can come back afresh if there is anything like that. Why should you continue? Up to you. Because the new circular doesn't have that clause. It's up to you.
Worship,
Because that particular observation is not there in the present circular.
Yes, that after hearing of the On 25th only, Lordship.
You can, I can come back after 26.
And
My lord, basic grievance was my lord, stopping the work. Since the deputy gonna withdraw that condition, partially my lord, it become
if
infrastructure.
that is so, then that can be recorded in the.
No, it's only part of the record.
You can say it's an infrastructure. That's all.
It's up to you.
Premature at this stage. It's your own document.
Oh, let the matter come up on 26th and as far as interim period can be considered on that day, that can,
How can we consider?
otherwise if,
There is no any restriction, my lord. Where is the question of interim order? my lord?
That imposition is not there now.
Hmm.
You are agreed by that clause. That is why he acted as jurisdiction.
we will attend the meeting and then we'll come.
When?
On 26th, let it.
Obliged, my lord.
Yeah.
Item number 26.
Yeah, please, Lordship. Lordship, I'm challenging the transfer order issued by the authority. Lordship will find at page number 37, Lordship, annexure I, Lordship. On the ground that, Lordship, this transfer order has been issued, Lordship, by way of a punishment, Lordship. Lordship will, I'll start, Lordship. Government of India, Lordship, in the year 2013, Lordship, in order to strengthen the Panchayat Raj system across the country, Lordship, has introduced the Rajiv Gandhi Panchayat Sasaktikaran Abhiyan, Lordship. And the cost sharing is 90 and 10% with the central government and the state government, Lordship. And accordingly, Lordship, in the 2013 and 14 plan, Lordship, this Rajiv Gandhi RGPSA, the state government has, the central government has sanctioned 591 posts for the computer accountant and 197 posts for the Panchayat technical assistant, Lordship. I am the Panchayat technical assistant junior engineer, Lordship. And accordingly, the advertisement were issued on 21/1/2014. Your Lordship will find at page number 27, Lordship. This is the, oh, sorry, Lordship. Your Lordship will start from page number 25, Lordship. This is the recruitment rules, Lordship, for a technical, for the Panchayat technical assistant, junior engineer, Lordship. Apart from having a position of diploma degree, your diploma engineering degree, Lordship, the candidate has to be a domicile of that particular district, Lordship. And in the, as per the advertisement, Lordship, 14 posts were sanctioned for the district of Kurumkume, Lordship. And after I appeared in the exam, I got selected, Lordship, and then appointment was made in the year 2014 itself, Lordship. What happened, Lordship? When I was serving as a Panchayat technical assistant at the Anchal Samiti, Samiti Circle, Lordship, at Kurumkume district, Procedural, Lordship. In the beginning of the year 2024, Lordship, this year, Lordship, one of the complaint has been made from the Gambura that regarding the short supply of material by the vendors MSGT Enterprise, Lordship, under MG Narega 2023 and 2024, Lordship. On the basis of that complaint, Lordship, committee has been constituted by the department, Lordship. That is on 3/6/2024, Lordship. Lordship will find that committee report at page number 35, Lordship. On the basis of this on the basis of Lordship says that this committee has been constituted, Lordship. In the meantime, what happened, Lordship? On 11/6/2024, this committee has visited the place of that place at Procedural, Lordship, to check the relevant records, Lordship. In the meantime, the ZPC, that is the respondent number 6, Lordship, he filed a complaint against me before the authority that despite our best effort, Lordship, we could not find that note sheet, Lordship. On the basis of that note sheet, I have been transferred from that place, Lordship. and the inquiry, Lordship, is still pending, Lordship. I, being a Panchayat technical assistant, I have nothing to do with the short supply of materials by the vendors, Lordship.
Tell us, what is the requirement for interference of this transfer order? What is the requirement of interference of this transfer order?
Lost.
You were at Kurung Kume for 7 years, 2017.
Lordship.
Now you have been transferred.
Yes, Lordship.
So-
Now the basic sole ground of the being transferred from that district to other district, Lordship, is that there is an inquiry going on, Lordship. Inquiry going on.
Whether inquiry going on, that is not been reflected in the order, and your transfer is not punitive transfer. Why should
Because
it be interfered? It's
Lordship,
not a punitive transfer.
Lordship, since from the reliable sources, I have learned that, Lordship, the ZPC has written a note to the department to transfer me from the district, transfer me out from the district. Lordship.
This impugned transfer order of the petitioner
Lordship.
from Kurung Kume district to Dibang Valley district doesn't reflect anything that it was punitive transfer.
Though it has not been reflected in the orders, Lordship.
Mm.
But
And also it is not your case that only to favor the other person who will be replacing you at Kurung Kume district, at his behest, the order was been passed. That is not your case.
Lordship.
So
Lordship, earlier in the similar situation, Lordship, when there is a pending work is going on in the concerned district, Lordship. In the earlier situation also, Lordship will find at the last annexure that the page number 38, Lordship. In that situation also, Lordship, the department has retained the transfer order, Lordship. Now, at my contention is that, Lordship, at this stage, Lordship, since there is several ongoing project is going on out there, Lordship, in my district.
that will be the prerogative of the authority concerned.
Lordship, at least, Lordship, so far as Lordship, this allegation is concerned, Lordship, at least let this investigation be completed at this moment.
No, that they'll do it. That they'll do it. But why should you interfere with this transfer order? So
Because,
ask
Lordship,
a valid reason.
Lordship, because, Lordship, there is one judgment of the Honorable Supreme Court, Lordship. It says that, Lordship, any transfer order issued on behalf of the politician or that cannot be sustained, Lordship.
Where is this? Which this transfer order reflects anything?
Lordship, I been to the office, but by filing an RTI, Lordship, it will take months. By that time, Lordship, this matter will become infructuous.
That is why we are asking you, show us a valid reason for interfering this transfer order, even for passing a stay order. But the other way, Honorable Apex Court have clarified.
Lordship.
First, you go and join your respective place of posting on transfer. Then you file a representation. That is a different issue. You must establish your case that there is a reason for interference in by lead court. There is nothing. Some other junior engineer serving as PTA was considered. His transfer order was stayed for a time being till completion of the work. That is the prerogative of the employer, not the prerogative of the person concerned who has been transferred.
Precisely.
So
now, Lordship, since at this stage, Lordship, at least my only humble contention is that, Lordship, since the inquiry is pending, Lordship, and the project is going on out there, Lordship.
That doesn't mean that you might say, to retain you your place of posting. It is up to the employer to decide. Why should you interfere? That is why they are calling us. This transfer order.
Lordship. And moreover, Lordship, this is just a contractual post, Lordship. It's not even a regular post also, Lordship. If your Lordship will kindly see the RR, Lordship, that is Annexure B, Lordship. It is particularly stated that only the domicile of the concerned district, Lordship. Now, I am the domicile of the Kurung Kume district, Lordship. I have been transferred from another district, Lordship. That is the Lower Dibang Valley, Lordship. At least, Lordship, at this stage, let them at least get an instruction, Lordship, and in the next state, Lordship, this matter, entire matter may be disposed of, Lordship. Well,
Who is appearing? 1 to 4.
in fact, Lordship, on the next day, I will not pray for extension of the interim order also. So next day, this entire matter may be disposed of, Lordship.
You come to page number 37. Yes, look. Page number 37.
37.
37. No. What it is? It's a e-file. So the file. There's a file number. You have seen the file number? The file number.
File
the
number.
top. Give it to us by Friday. This is from Itanagar only,
Yes, sir.
right? Or give it to us by Monday. We'll see. Yes or no?
Yes, sir.
Get that record by Monday.
Okay.
What's your good name?
Em Lawang. Monday.
For the petitioner and such. For the respondent numbers 1 to 4. Petitioner is aggrieved by the impugned order issued under memo number E5, E-file, number PR-EW/49/2017/8708, dated 13/06/2024. Wherein the director of Panchayati Raj Department, Arunachal Pradesh, issued the impugned transfer order the 13/06/2024, transferring the petitioner Panchayat Technical Assistant Udinvika Junior Engineer from Parsi Parlo Zilla Parishad of Kurumpoe district to Italin. You can see at page number 37. It is here. Okay. Italin, Maryland, Zilla Parishad constituency of Dibang district. List on. So Monday, on the same date, Mr. Such landed government advocate. You are standing counsel for Panchayati Raj or the government advocate? Government advocate such shall produce the file number, e-file number that you have written already, no? Before the court. Till then, the impugned order of transfer of the petitioner dated 13/06/2024 issued by the Directorate of Panchayati Raj. Till then, status quo is on today, with regard to the transfer of possessions, shall be maintained. Copy of this order to such and such, enabling him to place the relevant records in original on the next date fixed. I 24. Yes, sir.
Deeply obliged, Lordship.
Number 1.
Please, ma'am. Just a minute, please. Robico Bodna. Yes, please.
This petition was filed for release of pension and other retirement benefits, my lord. Some amount has been released, my lord. After, my lord, there's an order dated 22/12/2021. 22nd December 2021. This was the last order.
You are Mr. Pandey.
Yes.
Please take your seat. Let me go through the affidavit of the arrest number 2.
Yes, ma'am.
Just a minute. When did you retire from service?
Sorry,
When did you retire from service?
my lord, it was, the order dated is of 2017, my lord. With retrospective effect, I was compulsorily retired from 30th December 1997. After numerous rounds of litigation, my lord, finally order was released, and what dated order dated 2017, my lord, it was directed that I have been given major penalty of compulsory retirement with retrospective effect from 30th December 1997.
Please appear. Verify.
I'm appearing, my lord.
Yes.
All the,
You have given him the provisional pension.
not my lord, not provisional, my lord. We have paid all, all the service benefit he entitled, we have paid, my lord.
You have given him the PPO, pension pay order has been issued. Final pension pay order has been issued.
By,
We have not received, my lord, I have answered, my lord.
yes, my lord. If my lord, I have filed affidavit, my lord, in the place on record, my lord. And final order, my lord, one that is when I filed this affidavit, that was not my lord. I have placed on record this also, my lord. One order dated 25 November 2021, my lord.
Give it to us. Give it to us. It is not available here.
Now that order, my lord, he has challenged in item number 6, my lord. Final order, my lord. In item number 6, my lord, he has challenged this order, this final order, my lord. Now, as part of this petition, my lord, we have all complied all part, my lord. This petition to item number 1, my lord.
Item number 6, my lord, he has challenged this, my lord. Oh. And in that case, my lord, though I am yet to supply with extra copy, my lord, in item number 6, my lord. I have, but then I have on my own cost taken necessary step to the respondent, my lord, on 19.3, my lord. But I am yet to receive instruction on this, my lord.
Six, item
Six, item 6, my lord.
This petition has become infructuous in that case.
My lord,
Because in the second
in this
petition,
matter, and the item number 1, my lord, I prayed for leave encashment, all the retirement benefits I prayed for. Some money has been released, but to what account? Some money has been released, not the full account, my lord. So what I am praying, my lord, today is that they should file an affidavit, my lord. At least I should know what money has been given to me.
Affidavit, my
My,
lord, we
my,
already filed, my lord.
let me make my submission. I prayed for, my lord, there's an outstanding salary also, my lord, which is accruing, my lord. Interest is accruing. Areas of pension, gratuity, DCA, RG, leave encashment, and other retirement benefits I've seen. Some money has been released, not the full amount, my lord. And to what account, money, what amount has been released to what account, I don't know today, my lord. So my prayer is, my lord, ki at least I should note this thing. They should file an affidavit, what amount they have released to what account. Thereafter, my lord may dispose of this petition, my lord. My second petition, item number 6, will run, my lord, with respect to 1/3 portion of my gratuity and pension.
May I submit, my lord?
yes, please.
My lord, about affidavit, my lord. If my lord, see, my lord, what benefit we have released to him, my lord, we already filed affidavit on 18/11/2020, my lord. 18, we have put that on record before this corner. Now, after less of 2 years, my lord, he is saying what we have released, my lord. We are saying what he is entitled, we have released, my lord. Now, duty is cast upon him to what we to identify what we have not released, my lord. On 18/11/2021, my lord, we have already placed on record, my lord. We are saying we have released all the service pension benefit, my lord.
My lord, the final order is of 25/11/2021. After which my lord has passed, this honorable court has passed an order that you have to release the amount before 7/1/2022. This was the last order, which has been passed, my lord. So how can he say for the last direction was, my lord, that whatever amount you think that it has to be paid, you kindly pay it by 17/1/2022. After this date, I have received some amount in my account, my lord. I do not know to what has been paid, my lord. A workout of that I want, my lord.
Sorry, my lord. In terms of that order, my lord, we have filed this affidavit, my lord. My lord, kindly peruse, my lord, my affidavit, my lord. At para 2, my lord, I have given para 2 at page number 3, my lord. But para given back to state, the respondent has gone through the, sorry, before that, my lord. 1, my lord. Now, gone through the order dated 28/10/2021. This is page 3, my lord. This is the order, my lord, whereby, my lord, in this case, my lord, our affidavit, my lord.
I have not received this. I have not received this affidavit, my lord.
Now, there is no, now, that is why, my lord.
But this is after that order,
My lord.
this is the first time that matter is listed, my lord.
No, my lord.
Twice matter was listed, which I attended over VC, my lord.
That's why,
I
my
have
lord.
not received this affidavit.
I am saying, my lord will kindly peruse the order of this on record. From 2018, my lord, from 22 to 22/11 to 21, my lord. After this order was passed, my lord, the petitioner, my lord, remained absent on many occasions, my lord. That's why, my lord, this, my lord, have a kindly order of a series of order by petition report, my lord. After this order passed, my lord, we place on record, file affidavit, my lord. Immediately, my lord, we expectedly carry out the whole process, my lord. We place on record this whole affidavit, my lord. Thereafter, my lord, he remained on many occasions, my lord.
When did you file
Now-
affidavit? When did you file affidavit?
We filed that on, my lord, start from order dated of this honorable court on 28/10, my lord. 28/10 direction issued to us, my lord. 28/10, my lord. 2021, my lord. 28, my lord. Thereafter, my lord, we filed our affidavit on 18/11, my lord. 2021, my lord. 18 even 11.
Yes.
First, my lord, we place whole cases, whatever he intervened, except final order, my lord. Now, thereafter, my lord, from my lord, 20 to 12 to 20, my lord, he remained absent, my lord, on many occasions, my lord. That's why, my lord, this case is still pending, my lord. Otherwise, my lord, by order dated this final order, my lord, we have already, my lord, given him all the benefit, my lord. Order, my lord, will kindly pay this, my lord.
Come to page number 8 of your affidavit.
Pardon, my lord.
Page number 8 of your affidavit.
8, my lord. Yes, my lord. This is the, my lord, pay fixation, my lord. To
This
his,
is
my
your fixed,
my lord.
right?
My lord.
Now the pension on basis of that.
My lord.
By an order.
Thereafter, 9 is sanction order, my lord. Now, as per my lord, we ask my lord, we are saying, my lord, we have released, my lord. Now, after lapse of 2 years, my lord, he is saying he is getting not getting whole, my lord. So now duties cast upon him to what his entitlement we have not released, my lord.
His suspension order was revoked.
No, my lord. What happened, my lord? As he is suspected in the CBI case, my lord, he was dismissed from service, my lord. Thereafter, he opposed this honorable court, my lord. In terms of honorable court order, my lord, his dismissal order, my lord, was reversed into compulsory retirement, my lord. Now, compulsory retirement, my lord, that is not, he is not challenged that, my lord. Now, in terms of compulsory retirement, my lord, the pension, the final pension order is in consonance with the law also, my lord. In the,
After the order of his reappointment, right?
my lord.
Number. He was raised in service, his particular period of suspension was taken and as on duty.
My lord.
So he was supposed to retire when?
My lord.
When he was supposed to? Was retired from 30th of December to 1997.
My lord, final order, final order, my lord.
After the order, you have passed an order considering him to be as on duty.
My lord.
Right?
My lord.
That suspension period was considered as on duty.
My lord.
Now you have compulsorily retired him on 30th of December 1997.
My lord.
What would have been his basic pay?
In between, my lord.
His basic pay should have been what?
Pardon, my lord.
Basic pay, salary.
Basic pay, my lord, we that is at page number 8, my lord. My lord.
Up to which date?
Base picture, my lord, in is on 28 to 1995, pass, my lord. In terms of decision, B is of my lord, pipe revised pay, pipe pay commission, my lord. Revised, my lord. Now his entitlement, my lord, down below, my lord.
See, his, for the purpose of his pension,
my lord.
His salary last pay drawn would have been December 1997.
My lord.
His pensionable amount,
my lord,
was to be assessed,
my lord,
as on 30/12/1997. And since you have passed an order that you will release only 2/3
my lord,
and keep 1/3,
My
which is under challenge, that
My
is a
lord.
different issue. You should have released 2/3.
my lord,
But here, if you see, you come to page number 8,
my lord,
you have determined his salary, page number 8.
my lord, my lord.
Up to which date?
8, my lord. I am looking at it.
The salary was considered up to which date? Fixation of pay is there, page 8.
Yes, my lord. I have
What is
sent.
the date?
Date, my lord,
Where you are looking?
91/3/1997, my lord, last, my lord. Down below, my lord.
See that? If his pay was 19,400, then his pensionable amount should have been assessed on what basis? As on when?
Yes, on the last date, it will be one
I
third.
don't understand. You have retired, compulsorily retired him in December 1997. His entire fixation of pension should have been fixed as on 31st of December 1997.
My
Have you done that?
lord,
Have you done that?
the date, my lord, no sure, my lord. For date, my lord, I need to take instruction.
What instruction? Already the process is before you. Look at the papers.
Yes, my lord.
Fixation of pay. Read. Clause A.
My lord, I'm looking at it.
Read.
Basic pay, my lord, is on 31/12/1995, my lord.
There are two headings.
My lord.
First heading. Heading A. What is A? In page number?
A picture paid to the post of chief engineer, my lord. That was, my lord, pay scheme, my lord. Now, as a chief engineer, my lord. Now,
Right. You read.
oh, sorry, my lord. Fixation of pay to the post of chief engineer power, my lord. Basic pay is on 28/2/1993 rupees.
Now listen.
My lord.
His service has been on duty.
My lord.
So, why the basic pay will be on 28th of February 1993? You have compulsorily retired him 31st of December 1997.
My lord.
So, on which date his pension should have been calculated? Which date?
Pension, my lord, yes, my lord, from 1997, my lord.
Right?
My lord.
Calculation is done on what basis? That is why he is asking that some salary is due to be paid.
My lord.
So your duty was, after the order of the court, when his suspension period was considered as on duty, and he has been compulsorily retired on 31st of December 1997, his pension should have been assessed as on 31/12, salary as on 31/12/1997.
My lord.
After preparing everything as per the procedure, you may have deducted 1/3. That you should do. After all, the person is retired, he is 80 plus.
My lord.
84 now.
So
80.
you should have that kind of thing.
Yes, my lord, that time, my lord.
See, what is important, remember, you are also a court officer.
My lord.
Don't only defend a department like that. Other will be something else.
My humble submission, my lord. In this case also, my lord, we acted swiftly, my lord. As he is all as my lord. In this case, my lord, we will say, my lord, even notice was not received. We acted swiftly, my lord, and we got everything came. Now he remained absent for so many years, my lord. That's why, my lord, we could not understand, my lord, what is wrong, my lord. That, my lord, today, my lord, had rightly pointed something, my lord. So
you have retired him compulsorily on 31st of December 1997.
My lord.
Okay. You have also passed an order that his service suspension period of 2 years should be considered as on duty. Right? So he should be considered as a person or an employee up to 31st of December 1997. You calculate it, give it.
Well, that's why,
you have also issued an order on 25th of November, right? 2021. Now, when did the person retire? 1997. After 4 years, can you pass that order? What is the law? What is the law?
That time, my lord, I'm also, my
See,
lord.
you must know what is the law. Can you pass an order after 4 years of deducting such amount when you have already compulsorily retired that person in the 31st of December 1997? We'll take up this matter next Monday. You get the calculation from the department. Now we have seen that man was, the suspension period was considered as on duty. He was compulsorily retired on 31st of December 1997. So this calculation at page 8, that is why you read again, just read. Basic pay
As
as
on
on,
28 to 1993 is
it
rupees.
should have been what? This basic pay should have been what? 31st of December 1997, because his suspension period has been declared as on duty.
My lord.
So automatically, this amount of 6,300 on the right side, as on 1/3/1995, would have been enhanced. That is why read the calculation. Read the calculation. Tell us.
My lord, I'm sorry, my lord, I'm not very sure about, my lord. I'm not good on this, my lord.
You don't have to do the calculation. The office people will do the calculation.
Basic pay on
28th of February 1993. Then pay after.
Pay after one increment is lower in lower scale rupees 4,400.
Then
pay in the higher post to be fixed on 1/3/1993 under A part 12(1)A I in the initial stage in the scale pay of 5,900 to 200 and between 6,700 per month, rupees 5,900. DNI 1/3/1994 equal to 6,100, and 1/3/1995 6,100.
Then that is the 6,300. Come back to B.
Fixation of pay due to fifth revised pay, my lord. I believe this is pipe pay as part of pipe pay commission, my lord. Pay basic pay is on 31/12/1995 6,300. DRN allowance applicable at AICPI average 1,510 in between 1960 to 100 is on 1/1/1996 equal to 6,993. DA at the rate of
11.1%.
111. Interim leave first installment rupees 100. Interim leave second installment rupees 630. 10% of basic pay. Fitment weighted for 40% of basic pay is equal to 2,520 mil. Total 10,243. Applicable revised scale of pay corresponding to the pre-revised scale equal to rupees 8,400, 500 between 500 to 2,400. Pay fixed in the initial stage of the scale of pay 18,500, 400 to 500 to 2,400 equal to 18,400 with effect from 1/1/1996.
Do one thing. You make the calculation. Make the calculation correctly through the department. Ask them to prepare it. Okay? Then we'll do it on Monday.
Let's say, my lord, if he appear, if he did not remain absent, my lord, we have point out.
Why now department is fully aware what amount he will be getting it, right? Ask him to prepare. Are they also able to prepare?
My lord, a copy of the affidavit should be provided to me so that I can see them, my lord. I have not been punished.
Well, I'll start.
You are from out, you do not have a local council here. You do not have a local council.
I come from Delhi, my lord.
See, why don't you follow that? So many easy steps are there.
Ne-
Send email.
Let's say, my lord, my humble submission, in this case, my lord, once the court order passed, we act swiftly, my lord. But as my lord, respectfully, my lord, I cannot point out whether this is wrong or right, my lord. We file this on record, my lord. My lord, point out some today, my lord. I will communicate that, my lord. If
Now you have realized that he was considered as on duty during the suspension period. He was retired on 31st of December 1997. It's easy. What will be his basic pay as on 31st of December 1997? Thereafter, only the amount has to be calculated. Right? And when you do not see a council here, you must always take the email address, send it through email.
That's why in between, I try to communicate also, my lord, whether he has get or not, my lord. I through council, my lord, I try to communicate, my lord, whether he has gained some benefit or not. Now, yes, cannot point, my lord, whether this is wrong or right, my lord.
Item number 6. Item number 6.
My lord.
What is your stand?
My lord, I beg some time, my lord, to file a petition in this case.
Why?
My lord,
They have passed the order. Record is with you. Only the place it before the trial court by filing an affidavit. That's all. How much time it takes?
my lord, in this case, my lord, what happened, my lord? Not after notice, my lord, I was not served with the extra copy, my lord, in item number 6, my lord. But then I take step, my lord, on my own post to the respondent, my lord. Now, what I find, my lord, now in this item number 6, my lord, the final order, my lord, he challenged, my lord, there is no legal infirmity, my lord, in this, my final order, my lord. Until and unless, my lord, the compulsory the order, my lord, which put him on compulsory retirement, that is challenged, my lord. This is nothing, my lord. In terms of this, my lord, compulsory retirement pension is two, that can be two-thirds, my lord. And there is nothing wrong in the item of 6, my lord. There is no, I believe, my lord, no legal infirmity, my lord. My lord will say, have a look at this is CCS pension, my lord, 40, my lord. Rule 40, my lord, say, my lord, a government servant compulsory retire from service, a penalty may be granted by the authority competent to impose such penalty, pension, gratuity for both or rate not less than 2/3, my lord. Now he has been given 2/3 pension benefit, my lord. Now in his petition, my lord, he has nothing to say, my lord. What is a legal infirmity, my lord, in this order, my lord? And as per the this is CCS pension rule, my lord, there is no any legal infirmity. Until and unless, my lord, the order, my lord, putting him in compulsory retirement, my lord, is challenged, my lord. Now that is not under challenge, my lord. Only the final order, my lord, that he has challenged. Now this is in consultation with the this CCS pension rule 1972, my lord.
Okay. You are taking it up next Tuesday. You do the calculation, ask the department to
My lord,
calculation.
I'll
Okay. And regarding this, since the petitioner has not challenged the compulsory retirement, right? He is compulsory retirement. You are saying that clause 40 of the CCS pension pay rule should be applicable. Now, that is the discretion of the government.
My lord.
Discretion of the employer.
My lord.
That is why I'm sending it back.
Yeah, my lord.
Can be may.
My lord.
It is not shall.
My lord.
It depends. If the employer wants to pay him full, that is why she not beyond the full pension. It is very much clearly written. So that may you have to consider. The consideration up to the government, up to the employer. Now the employer wants to give him 1/3 deduction or less than that. It is everything is up to the government, right? So file your affidavit. Right. We'll have it on 25th. Next Tuesday.
What?
Next Tuesday. Coming Tuesday.
Coming to the, my lord, some the Tuesday, my lord.
As early as possible, my
No,
lord.
that is the reason. Say person
My lord,
is entitled to some amount. We are not on the part of the item number 6.
my lord.
You make together. Huh?
Yes, my lord. 6, my lord. One, my lord. I'll try to complete.
That's that is what is more important. You make both the numbers together. 302 AP 2021 with 523. I was just missing an order. An item. Just right. Item 1 and 6. Which list these numbers on 25th. Enabling Mr. Kamduk, right?
I'll permit, my lord.
I'll pardon. Listen. Dropped in necessary instructions in the matter.
My lord.
Also had put it under matter. Okay.
Can I give my evidence? A slip so that I can give my.
Keep that in there.
My lord, that counter, the affidavit should be furnished to it, that should reflect in the.
My lord, sir.
Give him a copy. No,
Otherwise, again, that will come
no,
up. my
he'll
lord.
give him a copy. Give him a copy.
Within hour, my lord.
I
I'll
will-
discuss after copy.
Mr. Premi will give him. Don't worry.
Obligation.
Yes.
In this matter, Lordship, government is yet to file affidavit.
What is the issue?
The department has already filed. My lord, Lordship may kindly come to the order passed on 16/8/2022. 16/8/2022, the paragraph 5, my lord. My lord, there was a little bit of extensive hearing, and the moot question involved here was slightly indicated. Lord, records of the was called for, whether the record has been.
Land Management Department.
My lord, it was it's by the government, man.
Department will not file.
Not required.
Your lordship, some more time may be needed, your lordship.
Lord, in terms of order, the 16/8/2022, let the records from the office of ADC Mungong be called for. In fact, after we have the summer break for disposal.
Only the agriculture department has filed the affidavit. Only the agriculture department.
The records actually closed. The rest will
Do you have the records with you? Do you have the records with you?
So some more time may be needed, your lordship. Produce the record.
There is another rate petition. Another rate petition allowed the record.
Connected, the petition has been pulled.
Where is the preliminary notification? Yes, where is the preliminary notification?
Lords, this
Where
is
is-
matters, lordship. Preliminary notification is at page number, lordship. Page number 51 of the read petition. Page number 51. In this case, it will be taken up for final disposal.
The state government in the land management department that's for number 2. On the next date fixed, shall place the records in original pertaining to LM -164 of 2011. Wherein the land management department by the preliminary notification dated 18/12/2011 under section 4 in bracket 1 of the Land Acquisition Act 1894 as amended, and final notification / declaration dated 18/07/2012 acquired the land involved, acquired 1440,1440737.20 square meters of land involved in this case. List on. Give us a date. You all give us a date after vacation. Mr. Partin, a date so that
Any date.
18 July.
there is one hearing day. 18 July is hearing day.
After the break.
18 July.
In the meantime, the records.
Copy of this order furnished to Government Advocate Arunachal Pradesh for unnecessary use. Get the records, then only we will be able to get. Keep this one.
Grateful.
Yes,
Item number 12 also, my lord.
12.
Yeah. My lord, on 17 July. After
Or we'll just make it immediately after summer vacation, a date to be fixed by the registrar.
Item number 4.
May I please your lordship? Lordship, this petition has been filed for direction to the respondent authority to expedite the process of framing or recruitment rules in respect of the post of director in terms of the judgment and order dated 13/02/2002 and 30/06/2023 passed by this honorable court in WPC number 981 under bracket 2001 and WPC number 309/2023, and to allow me to function as a director till framing of the recruitment rules, your lordship. Your lordship, currently I'm holding the post of deputy director, and initially I was appointed as a district tourism officer in the year 1999, and after serving as an assistant director on deputation up to 2001, I was absorbed in the same post against a vacant sanction post in the year 2003. And thereafter, I was promoted to the post of deputy director, which is Group A, and on the basis of recommendation of DPC. And so I have been holding the post of deputy director in present currently. So, Your Honor, in year 2001, a writ petition was filed by the Arunachal Pradesh Civil Service Officer Association before this honorable court, and which was disposed of by this honorable court with a direction to frame RR rules within 6 months. And I have annexed the order copy in Annexer 4 and page 53, and relevant para is para 30, your lordship, page 53, your lordship. May I read the relevant para, your lordship? Since the impugn appointment is passed, it is directed that government may initiate for framing the RR regulating the service condition of the Department of Tourism, including the selection and appointment to the post of director under bracket tourism or the equivalent post in the Department of Tourism with a reasonable period, preferably within 6 months from the date of receipt of this order, and the necessary step may be taken to fill up the post on regular basis. So, however, your lordship, the respondent authority, they have not complied with the same order complied with the direction of this honorable court. As such, I have made a representation to the respondent authority on 26/04/2023, addressing to the Chief Secretary of the State with a prayer to frame the RR rules and to promote me in the post of director, because I am the eligible candidate in that post, your lordship. And then thereafter, I have made a subsequent representation addressing to the same respondent authorities on dated 20/06/2023. And the same was not considered, your lordship. Therefore, I have filed a writ petition before this honorable court, which was registered in number as WPC 03/2023. And the said writ petition was disposed of on dated 30/06/2023. I have annexed the order copy of that writ petition in my annexure number 9, page number 113 to 115. So in that writ, the direction in that order direction was passed by this honorable court that my representation should be disposed of in terms of judgment and order dated 13/02/2002, and within 3 months from the date of that order, your lordship. However, although my representation has been disposed of, but it has not been done in terms of the judgment or an order dated 13/02/2002. So therefore, your lordship, I have a very limited prayer in my writ petition that the respondent authorities may be directed to expedite the process of recruitment rules in respect of the post of Director Tourism in terms of judgment and order dated 13/02/2002 and 13/06/2023 passed by this honorable court. And until that, I may be allowed to function as a director till the framing of RR recruitment rules, your lordship. So that is my prayer.
Who is appearing for the
My
tourism
lord,
department?
I'm for the tourism department, my lord. May I plead, my lord, lordship, in compliance with the direction of the Honorable Court, my lord, we have already framed the recruitment rule, my lord, and it will be very soon placed before the administrative reform department, my lord, for final approval, my lord.
When?
As expeditiously as possible now, but otherwise, my lord, RR is drafted already.
Now, it is in the stage of, or it is awaiting administrative approval.
Yes, ma'am.
It has to route through various departments.
Yes, ma'am.
Now, which are the departments which have already approved?
Administrative reform department, ma'am.
Any
Yeah.
other department, finance department?
Yes, ma'am. And personnel department, personnel to the chief secretary also, ma'am.
Whether it has approved?
Lordship, the chief secretary has directed us to initiate the framing of recruitment rule, my lord.
You have framed?
Yes, ma'am.
Draft
Yes.
recruitment rules have been framed?
Yes, ma'am.
Now, at what stage it is pending?
It is to be now sent to the administrative reform department, ma'am, for final approval.
It is not yet been sent.
No.
What is
And-
your instruction today?
My lord, my instruction is that recruitment rule is ready and it will be sent to administrative reform department, ma'am.
See, this order of the learned single judge was of 2002,
Yes.
right? We are in 24. How many years? How many years? 20 years.
Yes, ma'am.
Down the line of 20 years, you do not have the recruitment rules.
Right.
Where it is pending now?
My
File
lord,
is pending where?
my lord, our predecessor that was not initiated earlier, my lord. But after this subsequent order of this honorable court, my lord, we have initiated now. And
Can you show us the draft rules?
uh,
Do
not
you have
today,
a
my
copy of the draft rules?
not today, my lord.
Day after tomorrow?
Yes, ma'am.
You'll be able
I
to show?
can.
Okay. List on. On the request of Mr. N. Pada, Standing Counsel to the Union Department of the state. We'll have it. You get the draft rules.
Yes, ma'am. Apply.
Item number 8.
My lord.
Yes.
My lord, this regarding suspension, my lord, I need some more time, my lord. Because this, it's just come up for the second time, my lord. I sought for Paraguay's comment and I could not receive agent today, my lord.
Where is the suspension order?
Suspension order is on your lordship, page number 18, your lordship.
It's relating to the APCS Pesco paper leakage, my lord.
When the search sheet issued?
Charge sheet was, your lordship, he was, although your lordship, I haven't annexed the charge sheet, your lordship, he was arrested on 25/11/2022, your lordship.
My lord, charges is at there, my lord. Page 25 onwards,
25.
my lord.
Oh, it's in one
25,
memorandum.
26, my lord.
Memorandum.
Article charges, my lord, 26.
What's article of charges? Please? Your Lordship. Your Lordship, in this case, Your Lordship, our only grievance is that, Your Lordship, is that, sir, according to the CCS and CCA rules, Your Lordship, the authority should, after the complete, under the 90 days, Your Lordship, should either modify the suspension order by either extending it or revoking the suspension, Your Lordship. And in this case, Your Lordship, this is more than 90 days, Your Lordship. They haven't reviewed the suspension order, Your Lordship.
When that order is required to be reviewed?
Sir?
When that order is required to be reviewed?
The order is required to be reviewed after the completion of 90 days, Your Lordship.
When, in which circumstances?
The petition, Your Lordship.
When, what is the law laid down by the apex court?
Since, Sir Lordship, the petitioner was suspended, suspended by the order dated, Your Lordship, 1st December 2022, Your Lordship. It has been more than a year, Your Lordship.
True.
Okay.
It is applicable when the
Uh,
search sheet is not filed.
Yes, sir.
But here the search sheet has been filed.
No, Your Lordship, actually, in this case, Your Lordship, yeah, the petitioner has already gotten the bail, Your Lordship. On account of default bail, Your Lordship. Since the IO failed to file the charge sheet on the given mandate time of 90 days, Your Lordship, he was released on default bail. And after that, he already approached the authority by filing a representation, Your Lordship. But still, Your Lordship, no answer was given to him, Your Lordship. And Your Lordship, if I may say, Your Lordship, there in earlier few months, Your Lordship, there have been some similar cases taken up by this Honorable Court, Your Lordship. And the Honorable Court had granted some orders on our favor, Your Lordship. If Your Lordship may allow, I will just kindly show you guys show Your Lordship one of the case law.
See,
Your Lordship.
that benefit is given only when the search sheet is not filed. In the case in the memorandum charges have been filed.
Yes, sir.
That is the reason.
Remember, memorandum charges has been filed. I have replied, Your Lordship, with the
So-
to the memorandum of charges, Your Lordship.
The permanent proceeding is going on, my lord.
But still, Your Lordship, the 90 days period is over, Your Lordship. We have already replied to the memorandum of charges. The
If,
reply,
if the person concerned is kept under suspension and the memorandum of charges is not filed, then it's a different case. Right? But in your case, memorandum of charges have been filed much within 3 months, after 1 month or two.
Yes,
So how is the law laid down by the apex court will be applicable in your case? Tell us. You tell us what is the status of the representation. Well, CCS conduct rules. We have the CCS
Yeah,
conduct
please.
rules. Here it goes. Get that, get it. Don't. When he was released on bail.
And he got. Your Lordship, he was released on bail on 27 February 2023, Your Lordship. We'll find it on page number 19, Your Lordship.
What's your good name?
My name is Radhik Romini, Your Lordship. Petitioner name is Radhik Romini.
Petitioner. Block Elementary Education Officer. under the Directorate of DDS means what? Under the, in the office of the Deputy Director of School Education. Hello, West Siang District. Was arrested in connection with SIC within bracket PIG bracket close. PS case number 112/2022. Was arrested on the was arrested on 25/11/2022 in connection with such and such under section 120B 406 409 420 IPC read with section 78 7/8/13 of the Prevention of Corruption Act 1988 pertaining to paper leakage in the APPS CCE 2017 and other examinations that was under investigation and trial. Because of his such arrest, the state government in the Directorate of Education suspended the petitioner from service, which by order dated 01/12/2022, which effect from his date of arrest, i.e. 25/11/2022. Later, in bill application number 53/2023, Learned Special Judge, Prevention of Corruption Act, UPR, by order dated 27/02/2023, released the petitioner on bail. The respondents in the Education Department on 05/01/2023 issued memorandum of charges to the petitioner informing him as to why action should not be taken against him for violation of Rule 20 of the CCS within bracket Conduct Rules 1964, to which the petitioner on 23/01/2023 submitted his written reply. As the petitioner is in suspension in service from the date of his arrest, i.e. 25/11/2022, petitioner submitted that the respondent authorities in the Education Department till date did not review of his order of suspension, though more than one year has elapsed from the issuance of the said suspension order. Nor took any action in his reply to the Search sheet dated search sheet oblique show cause dated 05/01/2023. List on, just declared, on the next date fixed, Mr. T. Tagum, Milan Standing Council Education Department, shall apprise the court about the status of the representation of the petitioner dated 23/01/2023 that he had submitted before the disciplinary authority with regard to the memorandum of charges dated 05/01/2023 served upon him. List on
Your
24th,
Lordship, kindly a fixed date may be given, Your Lordship, after
24th.
vacation.
Monday next, 24th.
Okay, Lordship, 22, Your Lordship. 22 July.
Yes, Mr. Tagum, get the records. See.
July. 22 July. After
24th of July.
24th.
Next coming Monday.
or coming Monday. Okay, Your Lordship.
You only have to let us see the records, that's all. Nothing much. Yes, next.
Malal. Malal.
Highly obliged.
Item number 9.
May I beg your lordship? Lordship, this is a tender matter, your lordship. Your lordship, may I come to page number 30, my petition, your lordship.
My lord, this matter, all though they have made a site visit, whether they have submit tender or not, that is no proper instruction is received.
This is your tender process. There is a stay order from April 2024.
Otherwise, entire package, there is some mistake.
See, ultimately, who will be affected? And the tender process is in state.
Yes, your lordship.
Don't you feel government is not willing to do anything over? It is the tender of the government. There is a stay order from the court. They should be more involved. Where is the order, tender of this?
The due order is, your lordship, 10/4/2024.
Where is the
Page
order?
number 132 by annexure E. Herein, your lordship, only 4 packages where the dates were altered, your lordship, with regard to the first origin damage.
Why you have filed this petition?
Your lordship, my only humble prayer, your lordship, is that the last date which was cancelled, your lordship, that may be extended, your lordship. I may be allowed to participate. That's all, your lordship. It's a public undertaking. I don't want to keep it on stay, your lordship. I may be allowed to participate. They may extend the date. Because cancelling the entered NIT tender itself will also be problematic for the government. And I don't want, your lordship. My prayer number 4, your lordship. I filed my representation praying the department for extending the date. Let me participate. That's all, your lordship. Page number 139 to 142. Sir, 2 representations which I have filed. 139 is the executive engineer, annexure G. The last portion, your lordship, of the first page, your lordship, 139. Read them, your lordship. And verbally also, your lordship, I have asked them to allow me to participate, your lordship. The next.
Yes, your open instruction. Do you have the copy of the petition?
Yes, Your Lordship.
Yes. You petition.
I've served the extra copies. Your Lordship.
Come to page 132. Simple thing. Got it. The instruction is sufficient. Probably only to extend the date.
Actually, I tried to contact executive engineer. It's very difficult to get his number. He's not picking up the number. That is difficult. Anyhow, I'll get.
Remember one thing. You are a departmental council. The departmental authorities should not be allowed to sit over the head of the standing council. Standing council should sit over their heads. You are the court officer. Whatever you direct, they should obey.
Anyhow, I'll take instruction. Last.
Tell us when.
Today is Friday.
By Friday?
Friday.
You will get it on Friday?
Yes, it's coming.
Okay. Are they so powerful? Impossible. Right? They're not that powerful. You will appear for Rural Works Department.
Yes, RWD, standing council.
List on such and such. And declare Mr. Tag. Mr. Tagum, you're appearing for.
I just add number. I just come at that it. Number I just did that.
Rural Works Department. No links, the relevant instruction.
Number 8, Malad, it seems that it will be very difficult to obtain Malad. I'll obtain written instruction, Malad. Can it be on 27, Malad? It's Thursday, Malad, instead of 24 Monday, Malad. So usually there's difficulty in obtaining written
26th.
Malad.
26th.
26th.
Item number 11.
Yes. What is the case?
Petitioner is not here, counsel. Is the private respondent.
I am for respondent number 11, my lord.
I have filed my counsel on 25/8/22 already. Here, the petitioner have misled the honorable court saying that his MIBT has been dismantled, also, whereas the department, PW department has dismantled the labor break of their own lawsuit. In my para 4 and 5, I have clarified also. Because it was in dilapidated condition, deplorable and dilapidated condition, we have a lawsuit dismantled it and have built a new one for labor break lawsuit. We have given the photographs also of our labor break lawsuit. Newly built. We have come to the honorable court saying that no notice was issued to him, no so-called notice, and his barrack has been dismantled by the, is dismantling by the department. Nothing is there. And we also since the petitioner is not here, counsel is not. We'll leave it to you also.
Nothing survives. He was occupying government land.
Lawsuit.
The petitioner is occupying government land.
He is not in occupation of the government land also. The labor break belongs to the PWD department. After being dilapidated in condition, we have dismantled it. We just came misleading the court saying that without giving any summon, they are dismantling my MIBT. MIBT member. Member improved building type MIBT. We have clarified explained in my
Someone in the morning, Cha is not available today.
paragraph 5. Lordship.
We'll have it some other day,
Yes.
after 2 weeks. On that day fixed. Registry.
Right.
Item number 14.
Lordship. This matter, I am appearing on behalf of GBAM. He instructed with so informed that the pleading is complete. So matter will be listed on admission hearing. Pleading is complete in this matter. So matter will be posted on admission hearing.
Yes, what do you say? They're appearing for whom?
On behalf of respondent number 3 and 4.
I'm for 1 and 2, Your Lordship.
Stay order is in force. Stay order is in force.
Yes, yes.
What is the submission? What is your submission?
Fix for this one, admission hearing, Your Lordship.
It has come in admission in your orders. Orders. What's your good name?
Tukur.
Okay. Indian name, sir. Common advocate and then rest for number 3. Matter relates to legality and validity of the final seniority list dated 07/06/2023 pertaining to unskilled contingency staff of the Directorate of Economics and Statistics, Government of Arunachal Pradesh. The state respondents number 1 and 2, as well as the private respondents number 3 and 4, have filed their respective affidavits. Stay order pertaining to said seniority list of unskilled contingency staff dated 07/06/2023 is in force since 11/07/2023. As the respondents have filed their affidavits in the matter, release this matter for admission on
Your Lordship, after vacation.
23rd of July.
In the meantime, interim may we continue? Interim.
Till then, the interim order shall remain in force.
Machu.
Item number 15.
Your Lordship, about a petitioner, I haven't received any of the statement affidavit in opposition. I haven't received from the opposite party.
Your Lordship, in this, we have received a parawise reply, so need some more time for filing counter affidavit. For respondent number 589.
You are seeking compensation. When the road was built,
Your Lordship,
when the road was built, it was widened, it was made 4 lane or what?
yes, for
4 lane,
two lane,
2 lane. When?
two lane, Your Lordship.
When? Which year? Which year?
Okay.
Which year it was?
It is 2023.
When the land was taken over? For
Your Lordship,
widening
it has,
the road.
the cases since, pending since 2000, the work has, it has begun in the year 2017. And matter was earlier, Your Lordship, it was withdrawn from the Honorable Court in the year 2021. And due to the non-furnishing of the fact-finding committee report, the cases again refiled on the same matter.
See, in your petition, you have not specifically mentioned when this land was taken over. When the land was taken over. You said your land was taken over, correct, but when? When that double road was meant, it was made.
So several representation has been your submitted in the Deputy Commissioner of Persian. It's in the year 2021 itself. Your name may say Annexus B. Copies of representation submit to the Deputy Commissioner.
See, representation is something different.
Since then, they have not acquired the land. But then as the matter is concerned about the development of the state, has not been stayed.
When will you be filing your affidavit? Give us a date.
2 weeks, Your Lordship. 2 weeks time.
Give us a date, firm date. After 2 weeks, we'll find out.
After vacation, Your Lordship.
Give us a date, madam.
18, Your Lordship. Oh, no, not 18, Your Lordship. 17, Your Lordship. 16, Your Lordship. Huh? 16.
16 to publication.
MS Petroleum State Council submits. And that she has already received with the necessary instruction and the affidavit.
My lord, I'm appearing for respondent number 3, my lord. I have already filed my affidavit. My lord.
On behalf of respondent numbers, you'll appear for 5,
5, 7, 8, and 9, Your Lordship.
5, 7, 8, and 9 shall be filed on or before 18 July 2024. In view of the above, list this matter for admission on 22nd of July.
Obliged, my lord.
Most of it.
One second.
Item number 27.
That record, single bench matter. Record. Yesterday, immediate petition. Describe the petition yesterday, I called them. This is a review, petition. 240. Yes,
Lordship,
the order was that as per the requirement, whatever amount has been sanctioned, the work order will be issued only after per NIT,
Correct.
right?
Correct.
Now, why do you want to review that order?
Lordship, what happened in this case, Lordship? These the small schemes, Lordship, under state annual development agenda, Lordship. These some small works and it's urgent in nature, Lordship. What is state government did, Lordship? This work was, Lordship, by Lordship by opting for this urgency clause, Lordship. If Lordship come to Lordship page, Lordship 5050, Lordship. 5050, Lordship, annexure 3. This is the general financial rules, Lordship. If Lordship turn to next page, Lordship, that's page 51, Lordship. Now rule 129, Lordship. No work shall be commenced or liability incurred in connection with it until administrative approval has been obtained from the appropriate authority. In each case, sanction to incur administration has been obtained from the competent authority and proper so and so and so, Lordship. Here, Lordship, basically this is the Lordship, the normal precondition, Lordship. Before the work is, Lordship, commenced or executed, Lordship. And here, Lordship, if Lordship see the rule 29.2, Lordship. Next page, Lordship. On the ground of urgency or otherwise, if it becomes necessary to carry out a work or incur a liability under circumstances when the provision set out under sub-rule 1 of rule 129 cannot be complied with, Lordship. Consider. Here, Lordship, what happened, Lordship? These works, Lordship, have been, Lordship, done in anticipation, Lordship, because the work was required there, Lordship, on account of urgency, Lordship, and it was executed, Lordship. If Lordship see the work order, kindly come to page 53, Lordship. 53, Lordship. This work order was issued, Lordship, on 10 March 2006.
Okay.
10 March, if Lordship see the work order, Lordship.
Page number.
At page 53, Lordship. 53. Annexure 4 series, Lordship. On top, Lordship, work order number so and so, dated 10/3/2016, Lordship. On top, Lordship. Just above the annexure, Lordship. This is the, Lordship, series of work order, Lordship, which were issued on, Lordship, 10/3/2016, Lordship. This the judgment and order passed by this Honorable Court is on 11/5/2016, Lordship. At page 21, Lordship. This is after, Lordship, this work order has been issued, Lordship. And therefore, Lordship, before this order was passed, Lordship, the work was already mostly completed, Lordship. So therefore, in substance, Lordship, that writ petition was already in process, Lordship. And since this facts was not brought before this Honorable Court, Lordship, and in motion state itself, this writ petition was disposed of. So therefore, Lordship, my limited, Lordship, prayer that the judgment may be reviewed by closing date as has become in process, Lordship. Moreover, the pun was supposed to be lapsed by, Lordship, 31st of March 2016, Lordship. It was a lapsable pun, Lordship. So therefore, Lordship, even the amount was already released to them, petitioners, Lordship. Yeah, on contractors, Lordship.
So these are the situation lawsuit. Asian today lawsuit, the works, all the works were already have been completed and even the amounts were released also. Since lawsuit's direction remains their lawsuit, so therefore we are approaching this court for review.
Mr. Attorney. For the review petitioners. None for the sole respondent. The notice was served upon the sole respondent of the opposite party, MSS Onu Enterprise. It did not appear in the matter. Earlier, the sole respondent as petitioner filed a writ petition being WPC number 240 within bracket AP 2016. Wherein the present applicants, review petitioners were made the party respondents. The writ petitioner was involved in various contextual works like construction and supply of materials, participating in the data process, the writ petitioner contended that by following the codal requirement, the responding authorities should allot the allotment of works, but without floating the required NIT, we didn't make it notice inviting tender. The chief engineer, PWD Central Zone, within Megate, Government of Arunachal Pradesh, Itanagar, the executive engineer, PWD, 0 Division, Lower Sunshine District, without issuing any tender, contemplated to hand over work order to the private respondent, to the contractors who are closed with such concerned authorities. Considering the same discord by its order dated 11/05/2017, 16, passed in WPC number 240 within bracket AP 2016, referred by the sole respondent, disposed of the said petition at the motion stage itself, directing the state respondents therein to issue work orders which regard to the sanction orders dated 26/03/2016, 27/03/2016, and 28/03/2016, only after floating NITs and selecting the contractors in accordance with law. Full stop. While passing that order dated 11/05/2016 in WPC number 2040 AP 2016, the court also observed that as per the CPWD manual, as well as general financial rules and regulations, the department concerned is required to call for notice inviting tender against any work involving rupees 5 lakhs or more, and finding that all such works involved in said WPC 240 in bracket AP 2016 was above 5 lakhs of rupees to above rupees 5 lakhs. The court observed that the state respondents are bound to issue NITs for such works. By filing this review application, the review petitioners the State of Arunachal Pradesh in the Executive Engineer PWD 0 Division, Lower Sunsal District submitted that prior General Financial Rules 2005 is followed by the state respondents, by the state. While issuing any contractual works. Page number 51 of the review petition. Rule 128 of the State General Financial Rules 2005 provides as follows. Page 51. Rule 129, the State 2004 rules. (129) within bracket 1 is number 52. Rule 129 within bracket 2 stipulates as follows. It is submitted that on the grounds of urgency, as it was necessitated to carry out the work and incur the liability under the circumstances, the authorities concerned in the Executive Engineer PWD 0 Division following the provisions of Rule 129 within bracket 2 of say 2005 rules, allotted the relevant work to the concerned contractors by issuing work orders on 10/03/2016 itself, much before the order dated 11/05/2016. Before, don't write much, before the passing of the order dated such and such, passed by this court in CWPC number such and such. Pursuant to it is also submitted that pursuant to the work orders issued on 10/3/2016 by the Executive Engineer 0 Division PWD, the concerned contractors have already carried out as executed the contractual work allotted to them, and that these facts were not placed before the court while the order dated 11/05/2016 was passed in WPC number such and such. Hence, this review petition for recalling the order dated 11/05/2016, 11/03/2016, posting WPC number 11/05/2016, posting WPC number 240 AP 2016. We have gone through okay. Don't consider the provisions of Rule 129 within bracket 2 of the General Financial Laws 2005 of the Government of India and the Ministry of Finance, Department of Executive. Considering the fact that work orders were issued by the executive engineer, 0 PW division, way back on 10/03/2016. Following the provisions of Rule 129 within bracket 2 of the said 2005 rules. And since work allotted to the concerned contractors by such work order dated 10/03/2016, we are already over of the completed. As those facts were not placed before the court at the relevant point of time, comma, the court passed the order dated 11/05/2016 inside WPC number 2400 AP 2016. Considering the entire aspect of the matter, and the facts stated above, the order dated 11/05/2016 passed in WPC number 240 in bracket AP 2016. Is accordingly reviewed and recalled. That petition will be required 240. How will you get it? If the record is not available now. In view of this writ petition, in view of the order passed today, in the connected review petition number 06 within bracket AP 2016, the order with 11/05/2016 is hereby recalled. Since the work orders were issued on 10/03/2016, and the works have already been completed, this writ petition being in fluxus stands closed.
Item number 20.
May I please, Your Lordship, this is about a maternal death, Lordship. Maternal death.
What is the stand of the government?
Stand of the comments last time lawsuit, they given the directions also to them to bring instructions regarding the availability of blood bank in that relevant point of time. Also.
My lord, regarding that, I could not obtain, my lord, although I sought for, my lord, the concern, my lord, the medical officer in charge, my lord, he was on medical grounds, he was out of station, my lord. So that's why that part I could not obtain. And later on, my lord, subsequent order, my lord, the detailed treatment sheet was required to be produced. So accordingly, I obtained the treatment sheet in original form, my lord.
And lawsuit is very old case also lawsuit. It's 2012 lawsuit. The petitioners, that's a Junaki Mega, is the mother-in-law of the deceased lawsuit. And I'm doing on behalf of my grandson lawsuit. For that also last time, as per the instructions of this honorable court, I have changed the post list, post titles lawsuit. So basically lawsuit, it's a clear-cut case of the violation of right to health lawsuit. And if you see my para 3 of my petition also clearly I have written the lawsuit. One was that she was died after 5 hours. That is they have also if you see their cause of death also it was reflected as postpartum hemorrhage. Basically after the delivery, the bleeding that occurs is called a postpartum hemorrhage. That is a page 28 lawsuit. That also they have clearly reflected it is a PPH and is an anemia lawsuit. And prior to that also lawsuit, if you see in this case, they have admitted in their affidavit also lawsuit, affidavit filed by 1 to 3 lawsuit. They have admitted that prior there is no blood bank, number 1. Number 2, the patient was anemic. And they also add another issue that which I have raised in this writ petition is that lawsuit. There is a scheme under the Government of India lawsuit that is Janani Suraksha Sishu Karikram and JSY scheme, where that basically the scheme is for the safe motherhood and for the pre-treatment nursing. But in my case also, there is no such schemes benefit I have received. If you see my transportation charge also I have paid. If you see the lawsuit ultrasound, which was supposed to be do at free of cost under this scheme was not given to me. So that is where lawsuit, my humble prayer lawsuit, I have already given in my this one also to direct the lawsuit to the respondent party to deposit 10 lakhs, not in my name lawsuit, in the name of my minor, the grandson lawsuit. That's where I prayed because he was deprived of our mother also. She was deprived of good life because of the failure on the part of the state government to provide the blood in the relevant blood at that time lawsuit. If it could be prevent lawsuit. And if you see here, if you see the government's memorandum also, clearly in district hospital, in every district hospital, there must be a one blood bank. As per the officials, office memorandum of the state government also, it's given lawsuit. This is type copy. District hospital. And there is a various judgment also lawsuit which support my case.
Whether the government for the affidavit. Respondent or health department filed any affidavit.
My lord, in our case, my lord, there's a no negligence as such from the respondent side, my lord. My lord, so far, the case of the deceased is concerned, my lord. My lord, deceased, she was taking prenatal, my lord, antenatal checkup. That is usual during the pregnancy period. She was doing antenatal checkup at Konsar district, my lord. Different district, my lord. My lord, it was not a case that she was under the supervision and she was taking treatment, prenatal treatment at the Roing District Hospital. My lord, on 10th July, my lord, for the first time, the deceased was brought for delivery, my lord. And there's no negligence or from the part of the respondent side, my lord. So according to whatever record, because it was not even cesarean, my lord. It was normal delivery, my lord. And that anemic patient, the history of the patient, my lord, that had this been under the district hospital, that antenatal, the test, if it was done prior to that, then it could have been said that all this should have been set ready. But it's not a case, but because moreover, her when she came on 10th July 2015 at midnight, my lord, she was perfectly fine, my lord. Everything was normal, my lord, and she took the normal delivery. And thereafter, next day, my lord, there was a bleeding, my lord. And there later, my lord, it was died. And it is not a case that, my lord, the anemic patient, my lord, she has history of the anemic, my lord, anemia, my lord. She was an anemia patient. And because of such thing, my lord, it cannot be said that that was because of negligence on part of the respondent, my lord. That part, my lord, the para 3 in the writ petition, they have clearly, my lord, they have even clearly stated that victim was not registered under ASA worker, and she has done 3 antenatal checkup at Konsar district. After her husband transferred to the Roing, Lower Subansiri, she came to the Roing and was checking her antenatal Roing. Madam, so far the routine checkup of antenatal, madam, that part in Roing, this is not a true, madam. That was not done, madam. So in any case, madam, there's no negligence as such on our part, madam. My lord, negligence as such should be such a shocking, my lord. And petitioners invoking public law remedies, my lord. It's exceptional cases, my lord. And in case of public law remedies, my lord, the negligence, extent of negligence should be such that it should shocking the conscience of the court, my lord. Otherwise, my lord, my humble respectful submission, my lord. In this, in similar cases relating of claiming of the compensation, earlier the court has disposed of similar prayer and similar has disposed of, my lord. Michi Apa case, my lord, that was relating to Lower Subansiri district, my lord. My lord, see, this is of the same allegation, same nature, my lord. Now, my lord, the death of the victim, my lord, deceased. Now it's shown to be anemic, my lord. Anemia due to anemia, my lord. And detailed affidavit, my lord, of respondent 4, my lord, we have elaborated, my lord, in terms of doctor's observation as to how
It is the respondents admitted the fact that there is no blood bank at district hospital Rohini.
My lord,
This is in affidavits by the state as well as the health officer of Rohini district hospital.
my lord. My lord, so far,
And the respondent number 4 in its affidavit clearly stated that the victim died because of excessive bleeding after the childbirth due to uterine atony, uterine trauma, retaining placental tissue, and blood clotting condition. Right?
yes, my lord, that part.
So the patient was also suffering from severe anemia, as her hemoglobin level was less than 7. So had there been a blood bank in the district hospital Rohini, she could have been provided with some blood.
My lord, that is the only my lord point, my lord. So far, allegation of negligence on part of the treating doctors, my lord.
She was, her husband was in another place.
My lord.
And in that place, while she was there, in that district hospital, she was regularly visiting. And that hospital, district hospital, was aware about her health condition.
In a different district, my lord.
Different district. She came to be with her husband.
My lord.
During the period when she was supposed to give the delivery of baby. Now, in that circumstances, non-availability of a blood bank in a district hospital, what do you have to say?
My lord, only that is the only point, my lord. That, my lord, because of non-ability of the blood bank, my lord. But so for allegation part of the negligence, my lord, negligence part as such, it is, my lord, it's not. My lord.
It's one part of the negligent
My lord.
on the state respondents.
My lord, had that the deceased, my lord, prior to this incident, my lord, prior to delivery, if she ever visited prior to that, my lord, having had been consulted with the Rohini district hospital, my lord, prior to delivery, my lord, at least that the preventive measure could have been arranged, my lord. Even assuming there's no blood bank, but that the preventive measure, whatever, the blood percentage could have been checked, and if it was not viable and conducive for her to be for treatment at the particular or for her delivery at the district hospital, she could have been referred to the better place, my lord. Now that part, there's a lack on part of the deceased family also, my lord. My lord, when in a certain district hospital, my lord, in a hospital, suppose it's not there, my lord, if this was made known to the authority, district authority, this could have been prevented, my lord, and she could have been evacuated to the better place prior to that of delivery, my lord. And that was lacking on part of the petitioner's side, my lord. And had this been known to the petition, made known to the authority, and no any action and no preventive measure was done, then that could be a different thing, my lord. But it's not a case, my lord. And we have, even at the moment, very crucial juncture, my lord, we have done all possible way, my lord. Team of doctor were deployed, my lord, to save her life. And in circumstances, my lord, in certain case, that, my lord, is become inevitable, my lord, even in best way also, despite of best treatment, my lord.
Yes, simple, your lordship. Is only thing is that if there was a blood bank in that district, her life could have saved. That is the crutch of this case, lordship. And it's an obligation on the part of the state government. On the state government under Article 21 also, lordship, which is known fact, lordship. Every person every person have the right to have a healthy life, lordship. And regarding labor pain is concerned, if you see my this one also, para 3, I've clearly reflected that after transfer to the rowing also, I have done a check also. And it is the duty of the ASA workers, your lordship, it's the duty of the ASA workers for doing their responsibility. That I'm not going to argue in this case, lordship. But my point this year is that, lordship, my daughter-in-law's life could have saved if there was a blood bank. It's only the contention of my petition, writ petition, your lordship. And clearly, lordship, if you see their death certificates also, they have reflected that post-mortem, right? That means excessive bleeding after the delivery, lordship. And it could be, lordship, life could have saved, lordship.
What's your good name, ma'am?
Kenada. Kaninada.
Mr. Tagum, you are appearing for all.
Yes, my lord. Except, my lord, except 5. Respondent 5, my lord.
I will represent by whom?
It should be, my lord, government side, my lord.
Okay.
It is not necessary. Health department is the main party.
The deputy director, ICDS, my lord. It is
Integrated Child Development. Social Welfare Department. Is there any Social Welfare Department, standing council?
my lord, it's the government is appearing, my lord. Government is the panel advocates appearing.
Problem, standing council. Student number 1 to 4. Go ahead. Okay, just 1 minute, 5. Okay, sir. Please.
My lord, only my respect, my lord, this is such a sensitive matter, my lord. It's anything, my lord, this is what happened. It may lead to Pandora box, my lord. The way my petition is projected, man. Even in any minor case also that may cause serious, my lord, ramification, my lord. That, my lord, may consider that part of it.
One life is lost, lordship, in this case, and one child is being made orphan because of the state government.
Only
we cannot say this.
we should have been made known prior to that. That is, if you had, after knowing this fact, if you had not taken a preventive measure, that could be a different thing, man. Deeply obliged.
Obliged, your lordship.
Item number 21.
My please, your lordship.
Please take your seat. Let me go through that. Yes, Ms. Dengan, what is your prayer here?
Lordship,
What is your prayer?
Lordship, I have made prayer to not let them construct a permanent structure and to decide, Lordship, it is at page 9. But the medical department, your Lordship might have seen, they have constructed a temporary sub-center in the land, saying that it was given in donation. And they're making contradictory statements, of course. They're saying community land, then a land of my father and the villagers, and also my father. The deceased affidavit is contradictory in many parts. But I'm told that the PHC center has been shifted. I don't know how far that is true, because if that is shifted, part of my prayer become infructuous. Because I had made a prayer not to vacate the land, that I'm told it has been vacated.
Yes, Mr.
My lord, regarding shifting, I don't have any idea about my lord, because the first time I'm surprised just to know this. My lord.
She might have been informed.
I was
My lord,
informed
that's
just day before yesterday.
My lord. My lord. My lord, regarding my lord, otherwise, my lord, land is for public, is being donated by the public, my lord. That part. Shifting of the PS. My lord.
Come to the affidavits.
My lord.
Also going to the prayers. Petitioner is claiming the land upon which the construction was going on, right? So she said that either it should be taken over, it should be acquired as per law and just without vacant. The respondent's reply is the land was donated by petitioner's father.
Not only petitioner, public, my lord, particular community, my lord.
That is conflicting, contradictory, Lordship, in many parcels.
Petitioner's father, if you read it. And also in Kebang, 3 Kebangs.
My lord.
The decision was taken in favor of the respondent, where the father of the petitioner is also a signatory.
My lord.
Now, whether land was donated or not, because there was another agreement. Because petitioner's father sold that land to somebody else and took money. The land which was already donated to the government. That part is something different, which will not, this woman say anything further. But you get the information whether the entire land involved in this case, which are under occupation of the health department, whether they have vacated that land and shifted the office to somebody else, or have constructed there. Get that information.
My lord. This matter relates, it's related to other district matter, West Chang district matter.
I think now this would be under Siang district. If I'm not mistaken, this should be under Siang district, not West Siang.
That's why.
At that point of time, it was West Siang.
Village is clear. Patu.
Pangin.
Patu, it is Damon, Jomlo, Mungku. Come to page number 10.
Mala.
You give us the information by Friday.
Page number 10 of my affidavit, my lord.
10 of the petition. Okay.
There is a representation also in which he is written to the Deputy Commissioner Siang district, Pangin. So that means it would be under Siang district.
The plot is at Patu.
Yes.
Domong, Jomlo, Mongko. Now, whether it will be in West Siang or in Siang.
My lord, I have to take confirmation has to, my lord, I have to take confirmation in this aspect also. Because thereafter, my lord, subsequent many developments taken place. District created, and whether it is falls under Siang district or the West Siang, my lord.
At least 2 districts, right?
My lord.
Village is in 1 district now.
My lord, my lord, that is my lord, right, my lord.
Get the information. Friday.
Right, my lord.
That may, you have to just give a call.
My lord.
That much.
My lord.
Get the information. Whether it is in the West Siang or in North Siang.
My lord. My lord.
Also whether it's been, the PHC, it has been shifted.
List on Friday.
21.
Enabling Mr. Tagore, Standing Council, Health Department. In fact, Ms. Pangu, you can also help us because the Deputy Commissioner of the district can tell us straight away as to whether the public health center at Patu, within bracket, Domong, D-O-M-O-N-G, Jomlo, Monku, C-O-M-L-O, J capital, Monku, M-O-N-G-K-U. Is still you can be in the Astral district, Astral Siam district. Before that one go under Rumgong police station, RUMGONG. Astral district, Siam. Is still in existence, or it has shifted to a different location, public plot of land. Vacating its said premises at village Patu. That's a copy of this order. That's on Friday.
Deeply.
Of lunch.
No concern. None appear for the petition. Call. It's Thursday. They have to put.
My lordship. Lordship, if time permit, at least I need 5 minutes to brief the text.
Just a minute.
Yes, of course.
Just tell us the facts in briefs.
My lordship, in brief, lordship, respondent in the year 2004 has issued a circular, lordship, whereby the prohibiting the petitioner for hunting, fishing, and collection of the forest materials, lordship, namely area called Kosap Kosel, lordship. It is a Zoom area, Zoom land, lordship. That circular has been known to the petitioner in the year 2017, lordship. Circular was issued on dated 22 December 12, 2004. Somehow the petitioner managed to know in the year 2017. After this, the respondent, that is the EPOMR clan, has withdrawn this lordship circular. Page 43, lordship.
Yes.
Page 43, lordship.
Yes, then.
Then thereafter, lordship, after the withdrawal, lordship, the petitioner, lordship, on dated 37, 2020, has issued, lordship, reply to the said circular. Thereafter, lordship, crux of the case is, lordship, on dated 16/10/2020, lordship, annexure 5, that is relevant.
Do one thing because.
Yes, annexure 5, domestic discussion, lordship.
Domestic discussion, it was a family meeting. Lordship, for a moment, kindly see Lordship. Page 59, Lordship. This is the translated copy, Lordship. Page 59, Lordship. Page 60, it would be 11, Lordship. Married, Lordship. Gava member, Lordship, kindly notice me.
No, you are agreed by.
Agreed by Lordship, page 88, Lordship. Infin order is at page 88, Lordship. That is the order passed by the circle officer, CO Nityapadam, circle officer, Lordship. Whereby the forerunner issued by the village authority has been cancelled, Lordship. Only strand that this Lordship 16/10/2020 is a village level cover, Lordship. So petitioner has to approach before the appellate forum, Lordship. Appellate authority under section 46(1) of AFR, Lordship, 1940. 16/10, Lordship, 2020 is not a village level cover, Lordship. It was preceded.
Can you do a favor?
Yes, Lordship.
Prepare a date chart.
Okay, Lordship.
Right?
Yes.
Because since the matter has a related fact of 2004, give us a date chart tomorrow. We'll keep it as a part heard.
Pardon, Lordship.
We'll keep the matter as a part heard. You prepare the date chart.
Yes, Lordship.
You are appearing for whom?
I am appearing for the private respondents, my lord, for respondent number 4 to 20, my lord.
Okay.
My lord, he has not assailed the order just he has mentioned. He is just assailing the order of the deputy commissioner. That was the subsequent order after all this. He has not impugned the whatever he is saying, that family meeting. He has not impugned that. In this petition, my lord, he has not impugned that order.
Here the challenge is the order of the circle officer.
Yes.
Right, my lord.
Right. So whether the circle officer can issue such order or not,
Right, my lord.
that has to be looked into. Okay. You can prepare a date chart and give it to us tomorrow.
Okay, Lord.
Pardon.
Deputy commissioner.
Yeah. Definitely.
God bless.